And hello to those of you now joining us. Welcome to this Forbes Solicitors webinar on the new shared ownership regime. We have, as you will see, a stellar cast of speakers for you this afternoon, and I will quickly introduce them to you. I'm Dan Milnes from the Governance, Procurement and Information team. We have my colleagues Shauna and Lindsay joining us from the Housing and Regeneration Property Development side. And from our Complex Housing Litigation team, we have Emily and Lachlan, who it's fair to say has made a lot more of an effort than I have today. So bonus points for sartorial elegance, and apologies for my slightly more casual appearance. Hopefully we'll be able to pull that back. And it's not quite Dress Down Friday, but it nearly is. So let's make a start. So there is an awful lot to get through in the course of today. So I'm going to throw up the slides now. Hopefully the questions that you have very kindly provided to us ahead of the session, we're going to pick up as we go along. And there is a capacity at the end of the session for any questions you may have. If you have any as we go along, please throw those up in the Q&A box that you'll see at the bottom of the screen. And we'll all look at each other in the background and figure out which of us has got an answer of that for you by the end of the session. So with little further ado, we will put up the slides for today's session. So we will start with the, very quickly, what we're going to be covering today. We've got funding and contracts, which is where I come in. We've got development covered by Lindsay and Shauna, and home ownership also. And then Lachlan and Emily are going to come to the repairs aspect. And all of these are elements of the shared ownership program that are different in the new version that's coming into play. So as you'll be aware, Forbes is a firm with a notoriously urban vibe. So what better summation of the issues surrounding shared ownership funding than the classic from the notorious BIG, more money, more problems. And the more you are relying on the Affordable Homes Programme to get your buildings up, then the more that the strings that come with that funding may be an inconvenience to you. And the Wu-Tang Clan were right when they said that cash ruled everything around them. And as we'll be looking at in this first session, there's the mechanics of getting the funding in, there's the eligibility for that funding, there's the timing of that funding, and then there is the potential impact that right to shared ownership is going to have on the financial outputs of your program, all of which you've got to weigh up, ideally before you make a start. And that's probably where the most challenging part of this comes in. So in this first section, I'm going to look at what has come out of the work that we've been doing on the Affordable Homes Programme Grant Funding Agreement, the new 21 to 26 iteration. Those are the headlines. We're going to look at the deletion of conversion capacity, introduction of the right to shared ownership, what is secure legal interest and what difference does it make, and what that does to your cash flow. I'm going to say a little bit about repairing, the bulk of which is going to be covered by my colleagues later on. But there is an element of this which you're going to want to cover off upfront in your building contracts and in the insurance that you specify in any development or building contracts. So let's start with the first heading of conversion capacity. And this helpful chart showing cups to pints to quarts to gallons is what Google gave me when I tried to Google the phrase conversion capacity. And that would imply that Google already knew that this was being deleted from the Affordable Homes Programme Grant Funding Agreement. Will we miss it? Will it make a difference? It's important to remember at this stage that the rent policy statement and the rent standard are still the same as they were before, and still make abundantly clear that it is not possible to convert a social rent property to an affordable rent property without having the express permission of Homes England. The conversion capacity that was built into the old SOAP agreement, that was one way of demonstrating you definitely had the agreement in writing of Homes England to make those conversions. And the additional revenue from moving up from social rent to affordable rent, if you are lucky enough to be operating in an area where that does make an appreciable difference, that extra money was one of the things that you could demonstrate was available to fund any part of an affordable scheme that Homes England wasn't covering. So just in case you've got any old schemes lying around that you're pulling forward into the new programme, be advised that if you were looking at affordable rent uplift as a part of that funding, that might not be as accessible as it was previously. I'm not going to try to do the inimitable voice of Joe Strummer, but it is important that your residents know their rights, and it is fair to say that they generally do, in our experience, or have an idea of what they believe their rights are. So they have the right to shared ownership. Now, precisely what that means is going to be covered in more detail by Shauna coming up shortly. But what was of interest to me is that I like to be able to find one place where I can go and look something up so that I can be fairly sure that I've found everything I need to know. The wording in the AHP grant agreement currently reads, the grant recipient, so the RP, must offer the right to shared ownership in accordance with the requirements of this agreement, so the AHP agreement, the capital funding guide, and the RTSO guidance. The RTSO guidance is the very short summary of right to shared ownership, which was produced last year. There's also reference within the grant funding agreement to the shared ownership consultation outcome. So that's referenced as well, as is also the capital funding guide. So there are potentially 3 places you might need to go and look if you have a question about how right to shared ownership should operate. That is far from ideal, and it is to be hoped that this is going to be consolidated in the one place. And there's certainly a 5-year life on the current programme, so plenty of time for somebody at Homes England to pull all of this together into the one place. However, at the moment, be advised you can't just look at one of these documents and regard that as definitive. It's the compound effect of all of them together. How right John Lennon was when he said, possession isn't 9/10 of the law, it's 9/10 of the problem. And to carry that over into the world of the new shared ownership programme, it's understanding what possession even means that is 100% of the law in this case. And it's important to remember at this point that we're in contract world here within the grant funding agreement, and a word in a contract where it has been defined means what the contract says it means and not what you would mean if you used it ordinarily, or, as is most important in this case, what it used to mean under the previous version of the Affordable Homes Funding Programme. So what we're talking about here is the secure legal interest. And we're familiar with that from the Capital Funding Guide. We always used to know what that means. That has moved on a little bit in the context of how it applies under the new shared ownership programme. There are multiple versions of what's called SLI. There's the SLI for shared ownership accommodation, which is one version. There's the SLI for rented accommodation, so that's affordable rent. And there's the SLI for exempt, which are those properties where you don't have to offer the right to shared ownership. One of the key things that's moving here is previously the secure interest in land was about the nature of your ownership, not so much the nature of the land itself. This is something that Lindsay's going to pick up on in a moment. There is now a requirement for the RP seeking this funding to have at least a 990-year interest in the land. So however solid your interest in a 900-year lease, it won't be good enough. Not for this particular purpose. There are 4 ways of demonstrating secure legal interest. And what's important to pick up here is that only 3 of them are good enough to trigger payment. And the one that falls off the end is category D of the secure legal interest definition, which is I have a contractual right to acquire ownership of this land at a time in the future, subject to only conditions that are under my control. If you want any money advancing under the 21 to 26 Affordable Homes programme, you must have what they call a completed interest. So not a contract for future ownership, actual ownership in your name now before you can apply for funding. And that condition is stated at least twice in the elements of the agreement dealing with obtaining funding and when you apply for it. So quickly to illustrate, how do we think that might make a difference? Well, here is an incredibly crude diagram of, we're going to say for example purposes here, a turnkey scheme where land ownership moves at the end. So we've got potential initial acquisition cost being reclaimed. We've then got going further into negative as we run at build cost, but then we're reclaiming that when we get to the end of the build stage. And then the further income that we might hope to see from the scheme, whether by way of rent or by shared ownership sales, that comes in and it all looks very healthy by the end of the game. If in a scheme where land ownership changes at the end of the program, we can't have any grant funding until land ownership has moved, the graph changes shape. You have to lay out all of the money, so get to that lower point at the bottom of the trench there, before any money starts coming in. And in this example, if land ownership only changes right at the end, then all of the grant funding, including the acquisition cost for the land element, only comes back at the end when land ownership has actually moved. So adopting the same illustration of having the funding requirement in blue and the contingency in red, there's a bigger funding requirement and it's potentially outstanding for longer. And that's an important thing to build into any projections you've got for affordable schemes going forward. At what point can I actually get the grant funding, and how am I bridging or cash flowing my build costs until I get to that point? Might be that you've got the war chest to do it, might be you've got other income from which it can be managed. The important thing is, don't be proceeding with any projects on the basis of funding coming in at a point when it actually won't be eligible. So, which types of schemes now work better or worse if the point at which you can achieve drawdown on your grant funding makes a difference to you? So we've got here illustrated 3 common variants: the sketchy looking package up in the top left corner, we've got the golden brick, and we've got the turnkey. So in a package deal, classically, land ownership happens right at the start, back to back via the developer, straight into the RP's ownership, and then the building contract kicks in. So good news there is we've got land ownership on day one, and therefore we can start claiming that acquisition cost on day one. And as soon as we start doing any building, we're potentially eligible because we already own the land. So that's great. And this isn't a procurement presentation, so I'm not going to start into my usual, there are inherent risks involved in package deals. Most of you will have heard that at least once before. And rest assured, those of you who haven't will hear it soon enough. So package deals are good in this sense, potentially less good in other senses. What about a golden brick deal? In a golden brick deal, the RP, which I'm assuming for this purpose is the grant funding recipient, only gets the land partway through when the initial element of the building work has already been completed, usually by the RP's group development company or VATCO. So what we've got there is ownership hasn't moved to the grant recipient during the pre-golden brick work stage. So following the same logic through, the Affordable Homes Programme funding is not available until land ownership has moved. Now, it may be the case that we're looking at that as an enhanced element of the acquisition cost. So in that scenario, it may be that at the point when you incur the enhanced golden brick purchase price, that's okay because that's the same day you're acquiring the land. And it may be that that is how you can get back the money that's been spent in the initial stage. What you can't do is get any of that money back before the golden brick land transfer. And in a turnkey scheme, as illustrated previously, land ownership happens right at the end when the build phase is completed. Now, classically, that was always great news for procurement, arguably slightly less good news for other aspects of risk management. And now it potentially has an impact on cash flow as well. So really important to summarize on this point, to understand the nature of the scheme you're looking to take forward and understand what impact it's going to have on the availability of that funding. So as we see illustrated in this classic shot from Fisher versus Spassky. There's going to be a lot of thinking involved in doing this. And we have had a couple of questions when we were taking bookings on how should a registered provider project for the impact of right to shared ownership take-up? And also, in general, how should organizations adapt their setup to take this into account? We were discussing just before we started broadcasting, we haven't yet spotted the grant funding clawback mechanism having been released. It is trailed in the initial guidance on right to shared ownership as forthcoming, but hasn't been quite as forthcoming as that guidance has indicated. So what do you need to project for? Well, number one, you need to project for how the funding scheme might alter the cash flow of your program, just to make sure it remains as achievable and viable as you wanted it to be. Is there a need to budget for right to shared ownership take-up? Yes, there is, because the initial guidance on right to shared ownership does state that you should put into your projections the impact of affordable tenants triggering the right to shared ownership and thus triggering a grant clawback on that partial disposal. Exactly what that grant clawback looks like to be confirmed, but you'll have to take a look. Can we give you any suggestion as to what that percentage take-up rate is going to be? No, not at this stage. You might consider that it could be perhaps analogous to the hit rate that you're having on right to buy or voluntary right to buy or any of those other schemes that you might have been involved in. And if you can indicate that your tenant base has a relatively high or relatively low predisposition to take up this kind of right, then it might keep you in the right sort of ballpark in terms of any projections you have to make. Looking ahead to what you need to be thinking about at the procurement and contracting stage regarding defects and any repairs that carry over into the new repairing period, which Lachlan and Emily will be discussing later in the presentation. There is a considerable temptation as practical completion date or due practical completion date approaches to essentially break out the big can of expanding gap filler that you can see at the bottom of the screen there, squirt that into any bits of the building that aren't right yet, and then attempt to hand it over with a broad smile on the projected practical completion date. And you might conclude, well, that's just disreputable contractors trying to get out of the scheme quickly and get paid earlier. And that may be the case, but it is certainly also the case in a number of schemes on which I've advised that the registered provider is prepared to agree to practical completion happening at an earlier stage than it normally would, with the proviso that the works that haven't been finished yet are pushed back into the defect remedy period by way of an agreed snagging list. Why would an RP want to do that? Well, number one, it might, at practical completion, trigger the next tranche of drawdown from Homes England under the Affordable Homes Programme. That will be one thing. And I've certainly come across this in the past. The allocations team have already allocated those lets, or your shared ownership buyers are getting very antsy and wanting to move in on the day when you told them they could. And so there's actual continual pressure from the back end of this scheme to get it handed over and get the residents in, even if everything isn't absolutely perfect. So that temptation is going to remain the case, but how should you approach it in order that you don't end up on the wrong side of the new repairing rules? Well, there are two schools of thought here, reflected by the two quotations you see on the screen. It isn't, I'm afraid, safe to say in the realm of procurement and contracting that you can just ignore whatever you said at the start because things have moved on a few months or a couple of years during the build phase. Whatever you put in your contract at the start of the project is what the contractor's going to be able to hold you to. Now, it may not echo in eternity, but it's certainly going to be valid in 2 or 3 years' time when we come to practical completion. So if we have agreed that we're prepared to do practical completion on the basis of an agreed snagging list, or we've in any sense let the contractor off lightly in terms of defects or the time to get back to site or any of those other elements that you would normally modify in a construction contract, this might play very badly under the new regime. That would be the case because those defects might also show up in the affordable or shared ownership tenant's right to repair. And in that scenario, you may not get the option of getting the contractor back on site to do it for free. You may find that your tenant has instead gone off and got those repairs done itself, and you're going to have to pay for that, while at the same time possibly also having to release money to the contractor from the retention, which is the worst of both worlds. So if we're looking at getting those repairs or defects funded, here are 4 options, and in order of preference, let's not wish upon a star. We equally can't rely on anybody else in the transaction acting like they were a charity. Generally speaking, the registered provider is the only charity in the field of play, and nobody else is going to feel obligated to help. Is there insurance? Yes, there is. There's NHBC, there is Premier Guarantee, there's Build Zone, there's various others that are out there. Is that insurance going to cover what you might have to pay out to the tenants under the new rights? Well, listen on and you'll find out what those eligibilities and entitlements are, and then you can have a check as to whether your insurance will cover it. By far the best method, of course, is a large pile of the contractor's money, illustrated in the top right. That's the retention. That's the 3%, 2.5%, 5%, however much of the overall build contract you're still holding back against the defects list being fully completed. There is a partial release of the retention at practical completion point. So my advice would be, wherever possible, try to get practical completion to mean what it says. All of the things you need that builder to have done, come back to site and finished, get them finished, try to hand it over in a way that isn't going to trigger repairs and potentially even worse, demands from the affordable tenants or shared ownership tenants. That's enough on funding and contracting. I will hand you over now to the more dynamic world of development, and I'll hand over to Lindsay.
Hello, I'm Lindsay. I work in the housing and regen property team, and I'm going to touch upon the effect of existing leases, previous funding programmes and Section 106 units. Move on to the next slide. So in terms of units where ground was claimed under the 2016 programme, RPs can use their discretion in offering the provisions of a new shared ownership lease, which complete after the 1st of April, which obviously already occurred. So it's your choice if you want to use the new model going forward on those units. Next slide. So in terms of Section 106 units, there'll be a transitional period for units delivered under Section 106 agreement for homes with outline of full planning permission. From the 28th of June 2020, all shared ownership units delivered through Section 106 developer contributions will be required to be based on the new model to align with the delivery of the 2021 funding programme shared ownership lease. However, in areas where local plans and neighbourhoods have reached advanced stages of preparation, there'll be an overlay. So there's a requirement for the new shared ownership model that will not need to apply for sites with full or outline plan permission already determined or in place before 28th December 2021 or the 28th of March 2022 if there's been a significant pre-application engagement. This means that for those that have reached publication stage by the 28th of June 2021 and with substantial submitted for examination by the 28th of December, they will not need to use the new model lease. Areas that are not as advanced will have to use the new lease from the 28th of June this year. So looking at the lease term and viability, for shared ownership homes funded through the 2021 programme, the term was increased to a minimum of 990 years, which Dan has touched upon as well. In this rule, there's no exception to this rule. So this change will mean that shared owners will no longer need to apply for lease extensions in the first 20 to 30 years of the lease being granted, which means the property remains mortgageable and sellable. It's a benefit to the actual leaseholders. This reform also is cost saving to the leaseholders, as the lease extension process can be quite expensive and complex. However, the concern for developers, which Dan has touched upon as well, is in relation to the actual development title. So if the development title is leasehold and the lease is less than 990 years, that makes the site unviable as one being a secure legal interest. Moving on. So I think we had one question on lease extension, so we'll cover this at the same time. As mentioned, under the old model, shared owners can. But on the old model, shared owners used to have a lease for a minimum of 99 years, which means that they can go for, sorry, I'll start again, which means they can undergo a complex and expensive process for lease extensions. This is because in the UK Finance and Mortgage Lenders Handbook, leases of less than 80 years are difficult to charge them. But under the leasehold enfranchisement, it refers to statutory right for leaseholders to purchase their freehold or apply for lease extension. But shared owners do not currently have a right to lease extensions unless a staircase or the landlord has a policy allowing such extensions to take place. However, as part of a new model of shared ownership, the government's announced its intention to extend the statutory right to lease extensions to current shared owners. This current shared ownership, the current shared owners will be given the statutory right to extend their lease by 990 years. However, there's going to be issues with if the development title is leasehold and is less than 990 years, which means it can't be extended. But this has been looked at by the government and we're waiting the response to this. There's no update on that as yet. So now look at right to shared ownership, which Dan touched upon slightly as well before. This will be to give eligible tenants who occupy eligible properties the opportunity to purchase their social affordable rent homes, which were delivered through the 2021 programme on the new shared ownership terms, which gives the tenant an opportunity to purchase a stake in their home and then purchase further shares when they want to do so. So it's basically a right to buy on shared ownership terms. This again brings up the issue, This again brings up the issue as to RPs having leasehold interests of less than 990 years, which means some sites will be unviable for shared ownership and affordable rent if the lease on title is shorter than 990 years. Another important point to note is that RPs will be able to block a right to shared ownership sale in a case where the cost floor is breached. A breach occurs if the current market value is below the total amount spent on building or acquiring the property, including the grant invested in the property. Another important point to note is the sale of the first share in property acquired or developed for sale on shared ownership terms is not a relevant event, and that recovery only provides on staircasing. However, on right shared ownership sales, the initial sale amount is a relevant event and recoverable. And I'm going to pass over to Shauna now.
Thanks, Lindsay. So, hi, I'm Shauna. I work within the home ownership sub-team of the Housing and Regeneration Property team. Next slide, please, Dan. Thank you. So once a development has been through acquisition and site setup, it's then passed over to our team to deal with the plot sales and any post-completion transactions, such as resales and staircasing. Therefore, in this part, I'm going to be looking at the existing model lease and the new model lease to look at the comparisons between the initial percentage, the staircasing provisions, and the preemption and nomination provisions. I also want to mention the new requirements around the key information document that needs to be provided to shared owners. Next slide. So, under the shared ownership model lease for homes delivered through the 2016 to 2021 programme, leaseholders can only buy an initial share of not less than 25% and not more than 75% of the market value. But under the new model lease for the 2021 to 2026 programme, the minimum share has been reduced to 10% of the market value of the property. RPs can, however, use their discretion in offering the provisions of the new model form lease, meaning the 10%. Whilst the initial share has been reduced, Homes England do still encourage maximising the initial share purchase, and this is considered to be between 25% and 45% of the net household income being spent on housing costs. And Homes England also anticipate the mortgage amount to be between 2.5 and 4.5 times the applicant's total gross household income. Again, this is dependent on individual circumstances and the availability of mortgages at the time. An assessment still has to be carried out by a suitably qualified and regulated mortgage advisor or financial advisor to determine what share the purchaser can afford. This assessment has to be at no cost to the purchaser, and they're not required to take a mortgage through those advisors. These assessments should still be relied upon as the definitive and final source to agree the share to be purchased at the outset. Next slide, please. So, for both the shared ownership model leases, existing and new, staircasing provisions remain a fundamental clause. And with the exception of rural exception sites, designated protected areas, and older persons shared ownership schemes, all grant-funded shared ownership leases must contain provisions for shared owners to buy further shares of up to 100%. If RPs wish to make a variation to this, then they must seek approval from Homes England first. The existing shared ownership model allows for leaseholders to staircase in tranches of at least 10% and no more than 25% of the market value, that value being a price determined by a valuer. Homes England do, however, allow more than one separate transaction to occur on any one day if deemed appropriate to enable purchases in excess of 25%. So you might already be approving staircasing transactions for 50% or 75% to achieve that 100% staircasing. This existing staircasing schedule has been amended in the new model form lease. And the shared owner can now staircase in tranches of at least 5% with no maximum except where the portion percentage will result in the unacquired percentage being less than 5%. The new shared ownership model also introduces a new 1% staircasing schedule, which is in addition to this existing staircasing schedule and is a separate right for shared owners. Therefore, shared owners do need to consider both provisions when considering which is the best way to increase their share in the property. Next slide, please. So the new 1% staircasing schedule, as I've mentioned, is a separate staircasing right, and it allows a shared owner at any time or times during a 1% staircasing period, which is the period of 15 years from the date of the lease or the date of the assignment to the new leaseholder, to serve what is called an additional percentage valuation request on the RP, which is a written notice asking for an additional percentage valuation notice, provided that no request is served within 3 months of an existing additional percentage valuation notice. So an additional percentage valuation notice, getting tongue-tied there, means a written notice served on the leaseholder, which is in a form substantially in the new model lease, specifying the amount of the reviewed additional percentage value, which is the value of 1% of the equity in the property for each year during the 1% staircasing period. Unlike the existing model lease, the value of the 1% equity in the property is determined based on the house price index calculated by the Office for National Statistics and published by the Land Registry, and is also calculated in accordance with the appropriate calculation contained in the 1% staircasing schedule. The additional percentage value notice shall be served on the shared owner and will remain valid for a period of 3 months from the date of service. At any time during the 1% staircasing period, where there is no subsisting valid additional percentage valuation notice, the leaseholder may request a further calculation of the additional percentage value, and the landlord shall serve an updated notice within 14 days of receipt of such request. If either party is not satisfied with the value calculated, then they shall be entitled at their own cost to instruct a valuer to determine the market value. Notwithstanding this right, the requirement for a valuer only applies where a staircasing request is for a minimum of 5% on homes provided through the 2021 to 2026 programme, or a minimum of 10% for the previous programmes. The landlord and the leaseholder are to pay their own costs and expenses in connection with the rights and obligations contained in this new 1% staircasing schedule. Further, when transferring the freehold title upon final staircasing, and where there is an estate charge created by such transfer, the new shared ownership model lease requires a provision to be included within that transfer, stating that the remedies of Section 121 of the Law of Property Act 1925 are not available to the transferor. These remedies allow the owner of a rent charge to take possession of a freehold house and lawfully exclude the owner should the rent charge remain unpaid for 40 days, or to grant a lease of a property to a trustee to raise the required funds to cover the amount owing and the additional costs incurred. So these remedies will be excluded. Next slide, please. So under the preemption provisions in both the existing and new shared ownership model leases, the leaseholder is required to pay to the landlord a sum to final staircase where the lease is assigned when the leaseholder owns less than 100%. There are exceptions to this requirement, including where the lease has been assigned to a person nominated by the landlord. The nomination period in the new shared ownership model lease has been reduced to 4 weeks, whereas it was 8 weeks in the previous model. If the RP fails to make a nomination within the relevant nomination period, then the leaseholder is allowed to sell the property at open market value at a price below, above, or the same as a RICS valuation. A back-to-back staircasing would then take place, and in practice, the leaseholder would staircase to 100% before selling their interest in the property simultaneously. If, however, the proposed purchaser wishes to buy only the leaseholder's share or a higher share in the property, then they will need the RP's consent, and this should only be given where the purchaser meets Home England's shared ownership eligibility criteria current at the time of the purchase. So you'll see there's not much of a difference between the preemption and nomination provisions contained in the previous form to the new model lease, except that the nomination period has been reduced to 4 weeks. So you will need to ensure your internal procedures are in place to meet this turnaround. Next slide, please. So in the existing shared ownership model lease, purchasers can find the key information document at the back of the lease at Appendix 3, and this document provides help to shared owners to understand what they are purchasing. However, for homes provided through the new 2021 to 2026 programme, there is a separate key information document pack which is to be completed and presented by RPs no later than at reservation stage. So this needs to be done before you would instruct us. This is a condition of grant funding. The completed document should also be sent to the buyer's solicitor along with the memorandum of sale, and confirmation should be obtained from the buyer's solicitor that these have been provided to the customer. So again, you will need to look at your internal procedures to ensure that this is included within your reservation stage and that these are issued to shared owners prior to instruction of legal. That's all from me.
Well, thanks very much for that. And we're just going to round off this part of the formal part of the presentation before the questions with a review of what's happening with repairs and some very significant amendments to that. So yeah, I'm Rockman McVeigh, I'm in the partner in the Housing Litigation Department, and Emily, my colleague who's an associate in our team, is going to be assisting me with this section. She's going to look at the fine detail, and I'm just going to deliver some of the key headlines. Next slide, please. So anyone who's perhaps purchased a new build home might be familiar with the concept of an initial builder's guarantee. And so normally it's about 2 or 3 years as standard, and occasionally, if you're very lucky, you might get 5. Well, what the government's proposing is effectively a gold-plated version of this, which is a 10-year initial repair period in favour of the leaseholders. And this is going to be quite a revolutionary change to the way that repairs are going to be tackled in practice. Obviously, much of this will be underwritten by the NHBC guarantee, but as many of us have ever dealt with, anyone dealing with insurance will know, there's so many carve-outs and exclusions that it's very important to appreciate the additional costs that this could load onto the landlord and owner of the property. So what the purpose of this, by the way, is to try to give a little bit more of a fair wind to a shared owner in the first 10 years of their ownership. There's a perception, certainly, that once you get past the initial couple of years, it's going to be a lot harder because suddenly more of the repairs have to be undertaken by the shared owner. And this then undermines the ability to staircase fully out of shared ownership and into outright ownership. So this is going to provide a bit more of a guarantee and safety net for shared owners. The 10-year period will also come to an end if the shared owner does staircase up to 100% in the interim period. And also if they sell on during the first 10 years, then the balance, the unexpired balance of that repair free period will be passed on to the next owner. And the relevant terms are going to set out in Schedule 6, the model lease for houses, and Schedule 9 for flats. Next slide, please. So the real sort of revolutionary aspect of this is also that there's going to be a harmonisation of repairing obligations between houses and flats. Traditionally, the landlord of flats would carry out works to the structure and exterior and then recoup their costs from the leaseholder through a service charge, even if that's by way of a major works charge. Whereas the shared owner of a house would be expected to undertake, in most cases, all of the external structural repairs themselves, with only very limited services being provided by the freeholder for which the service charge is payable. Well, that is now changing, and the way that it's going to work for shared ownership going forwards is that the landlord has to carry out all structural and external repairs during the first 10 years, regardless of whether it's a flat or a house. And not only that, but they cannot recover the costs from the leaseholder during that 10-year period. And also, they're not allowed to delve into any sinking funds either. Now, as I said, hopefully the vast majority of such costs would be underwritten by NHBC or any other applicable guarantee from a builder. But if there is any shortfall at all between the two, then that shortfall has to be borne by the freeholder, the landlord. And so that is a very, very major change in approach. And certainly those additional costs are going to have to be factored into your viability assessment, as Dan has already mentioned previously. So if there wasn't enough bad news, that you're going to have to find more cash upfront for longer, and also give your shared owners more of a helping hand and provide lots of free additional support services, you're also then going to have to pay for everything for the first 10 years, pretty much. At least certainly for structural and major works. But anyway, let's move on to what there is in terms of the shared owners' responsibilities. Well, shared owners will, however, remain responsible for purely internal repairs. But again, the difference here is they're going to be given a £500 a year allowance from the landlord towards the first initial costs of such internal repairs, again, during the first 10 years. And this would cover things like installations in the flat or house for the supply of water, gas, electricity, and sanitation, and space heating and heating water. So it's going to sound rather like your Section 11 repairing duty for your weekly or monthly tenants, and it's going to look very similar. Certainly the first £500 worth every year. And that £500 can also be rolled over for a period of 12 months, so that if you have someone who doesn't use up their allowance in 1 year, they can then effectively get £1,000 the next year, which is obviously quite a considerable cost to the landlord. Obviously, if there is any work that has to be carried out under a warranty or guarantee or insurance policy, then the cost should be recovered through that in the first instance. But again, the shared owner is not required to cover the cost of any excess of any policy or any administration fees. Anything above and beyond £500 is then the responsibility of the shared owner. But there is no limit on the number of claims that they can make, as long as they don't exceed the annual allowance in total. Also worth noting that the landlord doesn't bear responsibility for any pre-planned refurbishment or anything that is decorative only in terms of those kind of works. Obviously, though, if there is something you have to repair as part of your general repairing obligation, and you then need to make good afterwards, so there may be some ancillary decorative works which need to be undertaken afterwards. One item of clarity which is helpful is that at least internal health and safety requirements to do things like gas servicing and electrical testing will remain the responsibility of the shared owner, as they currently do now. But it would be helpful to have at least that clarification put into the writing of the lease. So now I'm going to pass over, with that as being the general instruction, I'm going to give I'll pass over now to Emily, who will give us some more of the detail.
Thanks very much. So just carrying on to consider the general repairs and maintenance obligations. I'm sure you've got lots of questions popping up. So there's a requirement for the repairs to be essential and genuine in order for the shared owner to make a claim for the cost against its landlord. So we've been asked what is considered essential and genuine. Well, there's no such definition within the lease itself, other than that the landlord is to act reasonably in its assessment. And you may consider whether you will carry out an inspection of the property once you receive notification of a claim to check that it is indeed essential and genuine. Landlords won't be liable to pay the cost of repairs where there's been a breach of lease, so where there's any deliberate or avoidable damage. Oh, someone's struggling to hear me. Am I coming through okay? Yeah, okay, I'll carry on, thank you. Again, we've just mentioned that shared owners remain responsible for health and safety requirements such as servicing of boilers. So if there's any repairs required where they've not complied with their duties, then again, the landlord's not responsible for those costs. As Lachlan also mentioned, shared owners are responsible for decoration of the property under the lease terms. So check that they're not claiming for any items of decor, and consider whether it's an improvement. If the repair or the replacement includes an improvement of specification, then it's not eligible for a claim unless, of course, it's unavoidable. So next, we're going to consider some expectations both of landlords and shared owners. So not all of these things are necessarily written into the lease, and I'd suggest you have a look at the terms within Schedule 6 and Schedule 9 of the leases for houses and flats. I'll try and point out the lease wording as well as some of the expectations on landlords. So landlords will be expected to give shared owners a choice in who they can employ to carry out the general repairs, provided that they're Trustmark approved. And it may also be helpful for landlords to provide the shared owners with a list of approved qualified professionals at the point of entry. So this list might include your in-house repairs team or contractors that you use as well. But it should include alternatives to those to encourage choice. You'll be expected to introduce systems or use your existing systems to enable shared owners to notify you of work required prior to it being carried out, and again once the work's being completed. And you should explain clearly and transparently to shared owners what information or evidence is required from them in order to submit a repair claim. Now, the expectation is that you would approve or reject a repair claim within 7 days of being notified of a completed repair, provided you've received the required information or evidence. The lease itself states that you can consider claims in a timely manner and provide a written response within a reasonable time frame. So, like I said, 7 days is an expectation. You'll need to think about how you can achieve notification in that time frame. So if you do approve claims, that doesn't amount to acceptance by the landlord of liability for those repairs, and the cost remains the liability of the leaseholder to pay for the actual repairs. And the acceptance of a claim though is agreement by the landlord to contribute to those costs, of course, up to the maximum allowance. If you do decline a claim, then you need to respond within 7 days of receiving notification of the claim and provide your written reasoning as to why you've declined such claim. You'll also need to inform the shared owner of their right to dispute your decision and set out your complaints handling process. You'll be expected to approve and reject claims in a fair and consistent manner. So again, consider that when writing up your policies. And you might choose to include a pre-approval stage at initial notification, so prior to the leaseholders getting the works done. This might help to manage disputes, and also you might want to carry out an inspection of the property at that stage, ensuring, of course, that you give reasonable notice to the leaseholder. Again, the expectation is that you will reimburse costs within 21 days of approving a completed repair. There is a flexibility as to how you make that payment. It may be that you make payment direct to the shared owner's bank account, or you may credit it to the rent account. The lease itself states that the payment is to be made within a reasonable period. So again, the expectation is 21 days. Once there's been a successful claim and you have made payment, you will need to update the shared owner of their remaining allowance for that year. And also annually during the 10 years period, you will need to update the shared owner of the remaining allowance. In the event of emergency repairs, you should employ an alternative streamlined process to ensure that those repairs aren't delayed. So next, let's consider some expectations on shared owners. Shared owners will be expected to check warranties, to check that the repairs aren't covered through those. They'll be expected to maintain their home and ensure routine servicing and maintenance, as we've said, your boiler servicing, etc. And provide evidence that they're carrying out that servicing if you request the same. They'll be required to notify and, where applicable, seek agreement from their landlord prior to undertaking any work. So that's, of course, if you require pre-approval at the initial notification stage. And then once the work is complete, they'll be required to notify you and provide invoices and any further evidence that you require. And that's expected to be done within 21 days of work being completed. You're expected to use a Trustmark approved tradesperson, or, as I said, someone on your approved panel list. If they don't, then you have discretion to reject the claim. So they can't claim for do-it-yourself repairs or repairs done by non-professionals. And if you do request access to inspect a repair or to inspect prior to approving a claim, then the shared owner is expected to allow access. Finally, shared owners expected to inform the landlord immediately if they become aware of any external or structural repair or anything that might be covered under a warranty. So these are all just things to take into consideration when writing up your policies and procedures. to make sure that expectations look like reality and not like these attempts of baking. So that's everything from me. We will move on to questions, and I think we've got a little poll to come up if you wouldn't mind just type in your responses to them and just type in any questions you've got in the Q&A, please, and we'll run through those.
Yeah, just on that point, I'll say we've had a few questions pop up, mostly to do with the repairs. So we're doing well with that. It's generated a little bit of excitement, which is understandable. So I'll just run through a few of these. First question was, what about repairs on agreed alterations? Do these qualify? And my view on that is yes, they do, because the repairs apply to the premises as defined in the lease. And Schedule 1 of the model lease says that the premises include improvements, additions made to and fixtures, fittings and appurtenances in the premises. So it expressly refers to improvements and additions. So I've just popped an answer in on that one on the text. Another question here says, how far do the external repairs extend? Unadopted road, paths, or just the outside of the property itself? Again, looking at the exclusion, the expression in Schedule 6 and 9 of the model lease just seems to be the building itself, although it does include any service media which exclusively serve the premises. But in terms of, it shouldn't include things like highways and access roads. A couple more questions. Would this qualify for a disrepair claim if you then reject the repair? Yes, it would. I think if you breach the repairing covenant in the lease, then you are liable to be sued as a result of that. And then, how many times can a customer roll over the £500 is there a limit? Yes, you can only roll it over from 1 year to the next. So at any one time, you have a maximum of £1,000. So it's a little bit like when you roll over annual leave. You can only roll it from one annual leave year to the next, not to multiple annual leave years. So same principle applies here. I think there's another one. I noticed that DLOs can do the repairs in the lease. Is that correct? I don't know if you've got a view on that, Emily, but I don't see any reason why not.
Yeah, sorry, I was just looking into the next one.
All right. Yeah, I think it's, I don't see why not. I think the point is that the landlord has to make sure that the repairs are done. How you then go about it is another issue. And you can, obviously there's different consultation obligations apply if you're recovering service charges, depending on whether you go external or internal, potentially, but I don't see any reason why you couldn't do that. So just there was an
and we've been asked where we can find the new model lease. I'm going to try and type an answer with a link to it in there. If you go onto the capital funding guide on the government website, there's a little drop down for model leases and you can find it in there.
Yeah. While Emily's doing that, there is a question from one of the delegates saying, I've missed our responsibility for structural repairs for the first 10 years. I can't see how this would balance out anyway, so will we be left out of pocket? Well, I think obviously anything above and beyond where you can recover a warranty or guarantee, yeah, you would be left out of pocket. This would form part of your general overheads and costs which you'd have to bear yourselves. So it's going to be a massive implications for your funding models, and also for when you are procuring the works, you might want to think very carefully about who is offering the best guarantees on your new builds.
To add to what Lachlan was saying there, that's the thought that was occurring to me in response to that question as well. You would be out of pocket doing the structural repairs if it wasn't covered by whatever new build insurance you have made your contractor get for you. So just, it was always the case, I think, that people would check out which one they were getting. And if it came from a reputable provider, that was generally okay. But it's now definitely worth looking at exactly what that cover would extend to, as to what type of repairs it would do, because certainly the existing terms of those policies have not been written with this 10-year repairing window in mind. NHPC is for 10 years, this is for 10 years, that's as much as they have in common. They weren't supposed to be coordinated, and the probability is they won't be. Whether or not anybody's going to come into the market with a product that meets this requirement, I'd be surprised if anybody wanted to go out that far on a limb to tailor their insurance to affordable homes program. But there's an awful lot of affordable homes program out there, so it may be possible to talk to the insurers and see what they can do. Lachlan's absolutely right. You need to make sure you maximise the value you can get from your building contract here. And if you've only got a 12-month defect period in your building contract, you need to smoke out those structural repairs just as fast as you possibly can. So odd though it sounds and counterintuitive though it may be, you probably want to contact that new tenant as often as you can in the first year to say, anything wrong with the house? Anything wrong with the house? Anything at all? Anything you'd like us to get the builder back to look at? Because once that 12-month defect period has gone, you cannot get the builder back on site for free. They don't have to deal with it as a defect. You've now got to sue them under the building contract. And their immediate defence is going to be, well, if you say this was an inherent defect at the point of completion, how come you haven't noticed it for at least a year? Why hasn't it come to light yet? Yeah, the answer will be you quite literally painted over the crack in the wall and it's taken a while for it to become visible. So while it sounds odd from an RP perspective to be going to the tenant and saying, have you got any repairs you need? Can you tell us if there's anything wrong? You've at least got the opportunity then to get best value out of the builder. It's a good point at this point to Trail that we are, I think, booked to, as soon as this session's finished, we're going to record some podcast extras, because what we found out as we've been talking about these issues between the team, there's more than we could fit into an hour, and we've already gone a little bit over, I can see. So what we're going to try to do is capture some more of our responses to the questions and some of the questions that we've been asking each other. So hopefully, if you haven't had enough of the new shared ownership model by now, and bearing in mind you are stuck with it for at least 990 years, it might be worth checking out what else we've got in terms of that podcast and keeping an eye out for anything else that we're bringing forward on our various social media platforms, which my marketing colleagues tell me we populate with all kinds of useful content. Do we have any other questions we haven't covered so far?
Well, in terms of the Q&A, Dan?
Yeah, I think we've gotten there about her contents insurance.
Yeah,
which is a good one.
Well, there's the contents insurance. I mean, it's possibly a little bit of a false comparison, because if you are in breach of your repairing obligation and that causes damage to the tenants, then you as a landlord have to cover the cost of that, regardless of whether it's insured or not, by the customer. Because ultimately, if the customer's got home contents insurance and then they pay out to their customer, but it was ultimately your fault, then you can be fairly sure that the insurance company will subrogate its claim and bring it back against you anyway. So either way, you will end up paying out where you have to pay out. Whether the customer has insurance or not is rather irrelevant. Whether they have contents and insurance for their own for accidental damage and things like that, which are that's their business and their concern. It wouldn't be anything to do with you.
Yeah. I think to take the car analogy insurance, if you are the other driver concerned, then you've caused that problem, however good or bad the other person's insurance might be. If you weren't the cause of it, and you've got people who are effectively looking to use this repair right instead of bothering to have insurance of their own, then I think you could presumably take a more robust position on that if you weren't the cause of it.
So three more questions on repairs. One is saying, if repairs are being rejected, for example, if the boiler has not been serviced, would that then mean they can never claim for the boiler again, or would servicing it reinstate the ability to claim? I think it would depend on the reasons why the disrepair had arisen in the first place. So, for example, if the reason the boiler is faulty is because it wasn't serviced, then you're not responsible for it in terms of the cost until it has then been repaired. Once it has then been repaired at the leaseholder's cost, then it resets the entire relationship. I don't think it means that, for example, if servicing would fix it, then presumably all you need to do is service it yourself, and the leaseholder pays for it, or the leaseholder pays for it themselves. And then, provided it is then in repair, then that should be fine. But obviously, if it invalidates any warranties or anything like that, then there may be a further. You might have a dispute with your leaseholder if they've done something that's caused you extra expense. Somebody asked, does the rollover spend have to be used by a certain date in the next year, or is it extended for a full 12 months? I think it's extended for the full 12 months. So if it rolls over, it rolls over. And then last one on the repairs was the claim for general repairs. A claim should be made from any warranty first before the £500 allowance. Does the onus to do that, for example, contacting whoever the policy provider is, now move to us as the landlord, or does it stay with the leaseholder? My reading of it is that it's a bit of a sort of shared exercise, in that the landlord is due to assist the leaseholder in getting the repairs carried out and claiming on any necessary warranties. The leaseholder stumps up the costs initially and then recoups the cost from the landlord. I think, is that correct, Emily? Is that we all reading a bit as well? Yeah, Emily's nodding away. So yeah, so that sounds about right. So it's kind of a bit of both, I think, is the answer to that question. There's one more question about I think is more for extending the leases.
Yes, so any existing leaseholders will have a right to extend their lease by 90 years. But that would be right that they can.
Yeah, and I think it's worth noting that there is some legislation in the pipeline anyway regarding the extension of the rights to extend and rights to enfranchisement as part of the whole broader leasehold reform package that's being put through Parliament.
Which I think so far hasn't fully resolved the question of, under the previous schemes, you could have bought in, certainly in the Northwest, the 800 years that were left on a 999-year lease granted way back when. And that would have been okay, and you could have granted your 99-year lease out of your residual 800 years, all of which would have been fine. What we don't know at the moment is how that 800 years that you've got can magically be turned into 990 if that becomes your shared ownership tenant's entitlement. So watch this space. If and when we do have a former colleague working at the Law Commission, so perhaps she can solve this. That would be good. Other than that, it is going to be quite an achievement if, contrary to all pre-existing property law, the government can turn an 800-year lease into a 990-year lease because they want to. But you never know. And in truth, if it expands the underlying ownership that you have as the RP, then potentially no bad thing on your part either. It will be a very long game on the part of the underlying freeholder to be banking on getting the land back in 800 years. So it may be that realistically this is something that seems like a problem, but might actually be resolvable without causing too much disruption to the property market. We'll come back to you when we know any more. So I think if that covers us on all of the questions, we've gone over a little bit. So thank you for staying with us, those of you who've been able to. Thanks for your attendance this afternoon. If there's anything further we can assist you with on implementing the shared ownership model, the new version, into your organisation, please do contact your either any of us or your usual contact at Forbes, who will be able to put you in touch with somebody who can do that. Can you get a recording of this? Yes, you can, because I believe a recording of this is being prepared as we speak. And as a data protection officer, I've got to confess I did click the consent button. So there is no going back on it now. So yeah, absolutely, we can do that. And we'll also make available the slides, use a bit of an aid memoir alongside that as well. So hopefully that's been useful. Thank you very much for your time this afternoon. And we'll now head off to record the associated podcast. Thank you very much, and we'll see you again soon.